Hello everyone, we are going to look at Monongalia County Planning Commission's MCPC Subdivision Ordinance for the exempt and minor subdivision.
The Monongalia County Planning Commission, MCPC, goes by many different names interchangeably. Some of these names include Monongalia County Planning Commission, MCPC, Planning Office, PO, Monongalia County Planning Commission staff, MCPC staff, and staff. For the purposes of the Subdivision Guideline Toolkit and reference videos and PowerPoint presentations, we will use staff as the only convention when talking about the staff within the Planning Office. We will use MCPC when talking about the ruling body of the Monongalia County Planning Commission, which is represented by seats within all jurisdictions within Monongalia County. We will use county when talking about everyone or thing within Monongalia County, including but not limited to the citizens, the businesses, the traffic, and the stormwater management of Monongalia County, as well as the staff and the MCPC.
What is a subdivision? A subdivision is the splitting of one or more parcels into additional parcels. It refers to the actual act of subdivision of land, opposed to a residential subdivision, which is a land or housing type, although they are related. Within the Subdivision Ordinance, there are three types of subdivision. An exempt subdivision, which is parcel divisions that are exempt from the technical aspects of the ordinance. There are 8 types of exempt subdivisions: family, cemetery, agricultural, or other resource extraction subdivisions, division of land pursuant of a court order, minor boundary adjustment, merger, or the creation of a utility or emergency services parcel. Note, according to West Virginia law, no subdivision can be declared exempt unless the MCPC or its designated staff determines that it qualifies. A minor subdivision, which is parcel divisions into 5 or fewer parcels, including the parent parcel, and that do not include off-tract infrastructure. A major subdivision, which is parcel divisions into more than 5 parcels, or that do not meet the exempt or minor subdivision requirement. Generally speaking, there are 4 types of building classifications associated with subdivisions. Residential subdivisions, which include mobile home parks, single-family homes, townhomes, apartments, and condos, or multiplexes. Commercial, which include malls, office complexes, and retail centers. Or industrial or manufacturing, which include business or industrial parks. And mixed use, which includes some combination of the other 3. The flowchart or timeline above, labeled exempt plat, is the process of applying for an exempt subdivision. If the applicant submits an exempt application, the staff has up to 15 days to declare the application complete. Once the staff has a complete application, then they have up to 15 days to determine whether or not the application qualifies as an exempt subdivision, and to determine if the plat is correct and complete. If the application does not qualify as exempt, that does not mean it will be denied. It means that it will have to be applied for under a minor subdivision as described later in this presentation. After the application is accepted as an exempt subdivision, the applicant has 30 days to file the application with the county clerk. That is the maximum time frame. These are usually fairly simple processes and can often be handled on the same day. A minor subdivision is basically any subdivision that involves a parcel being split between 1 to 5 times, including the parent parcel, and does not qualify as an exempt subdivision. Up to 5 houses may share a driveway provided a shared use agreement is provided and agreed to by West Virginia Division of Highways, or commonly referred to as WVDOH or DOH. We will now show an example. In this example, we are depicting a parcel of roughly 5 acres that someone wishes to subdivide into lots where water and sewer are not available. In this example, a standard or typical minor subdivision development would be 4 lots with long driveways, each with separate road accesses. The steep slope, indicated in red, does not typically allow for development. Excluding the steep area in red, the development has less overall land than a typical 1 lot per acre for an area that is not served by water and sewer. Without the MCPC aided design, or as we call it, FIRD design program, Preferred design would allow the developer and the staff to work together to create 5 lots by strategically avoiding the steep area indicated in red that could become a common area maintained by an HOA or something similar. This creates shorter driveways with a dead-end road indicated in yellow. Preferred design would allow the dead end to have a right-of-way, ROW, to possibly allow access to the land behind it in future, which is indicated by the blue road. The 5 properties would not be responsible for the development of the future road. If pursued, the next developer, or DOH, would be responsible for it. Preferred design would allow the developer to perform a percolation test on the layout to ensure buildability before expending money on the lot. If only one of the lots perked, the developer could work with the staff to redesign for a common leach field using the Randall Arnold Conservation Subdivision design. Now to the application process for a minor subdivision. The first step is usually a sketch plan or a concept plan. These 2 terms in a minor subdivision can be used interchangeably. They are both optional. If a formal concept plan is submitted, the staff must respond with comment in no more than 15 days. This allows the staff to explain the process and vet the ideas of the applicant before they encounter any significant expenditures like engineering. One of the principal benefits would be staff assistance to determine the allowable number of lots and the most general layout for them. That way the applicant can verify if the lots opposed are buildable from a legal sense, including, if necessary, the appropriate percolation test for lots not within an area served by water or sewer. It would be a shame to pay for the design and engineering and not be able to build anything. Note that the concept review can be extended an additional 20 days if the MCPC sends it to DOH for review. This step is critical for a smooth review process because it engages the outside entities like DOH, DEP, MUB, the State Fire Marshal, if applicable, early so they are not put in a position to reject the application at the end of the process after all of the work and engineering has been performed. It also allows the applicant and the MCPC to move forward with reasonable confidence that the review process is consistent with the outside entities and that they are not forced to guess what those entities might determine. As a general rule, this would not extend the maximum date for the review as a whole. After the sketch plan review would be the pre-filing application submission. This is a formal filing and application check and begins the formal time clock. An official application is both checked to ensure that all forms are submitted correctly to accept the application for formal review. For the minor subdivision, since the staff determines completeness, the staff determines both whether or not the application is properly filled out and that all necessary information for the case at hand is provided, i.e. completeness. The staff then has up to 10 days to declare the application complete. This step is mandated by state legislation and is intended to ensure that the staff has all pertinent materials to address the unique complexities of any given site. For example, in one situation, traffic may be important, and in another, the proximity to a steep slope or a school would be important. This is to determine necessary information and ensure that it is provided for appropriate plan review. Once the submission is accepted by the staff can immediately follow through scheduling. The next step is classification. Once the staff has a complete application, they have 10 days to review the application for classification review. The classification review is to ensure that the development is a minor subdivision, not extent, not major single phase, or major multi-phase. Once they have verified the development is a minor development, they would move on to a tech review. If the development is not classified as minor development, then the applicant would need to follow the steps of the development's new classification. Once the staff has a classification review, they have 10 days to review the application for approval or denial upon all planning and technical aspects of the application. The applicant then has 30 days to file the plat, i.e. the drawing or deed showing the subdivision of land, with the county clerk. That is the maximum timeline. For simple subdivisions, it will usually take less time. An applicant can always opt to be reviewed by the Planning Commission. but then they would have to follow the timeline or flow chart as if the application was for a major single-phase subdivision. As that takes longer, most applicants will not choose this option. There are 3 reasons the MCPC may need to hear a minor subdivision. First, reclassification of a subdivision from minor to major. This happens because the development proposed does not meet the additional guidelines set forth in the ordinance, such as the application proposing a multifamily development, commercial development over 5,000 square feet, or the need to extend infrastructure such as roads or utilities to the site. Second, a minor subdivision may need to go before the MCPC due to the request of a waiver from specific requirements or conditions. Third, there is the planning director discretion, where the director feels the application is appropriate for the MCPC to review due to project-specific or special concerns, e.g., if the proposed subdivision is in a targeted development area like an opportunity zone. In all 3 cases, the process would follow that of a major single-phase subdivision. See Major Single-Phase Subdivisions for more information.